basically. But this is something, an area which is exclusive of what we are going to study under the concept of public international law. There is this one student, I think there is some network issue at the end of Ayush Sharma. I just inform him that he has been getting admitted, but some network issue is there at his end. Then I said that this private international law is a domain altogether different to what we are going to study under public international law, right? And what forms private international law? It is the conflict of laws which are domestically formed, right? There are certain of lately there are certain efforts with respect to formation of treaties as well, because as I have informed in the early part, though more in detail, we will go into the history of public international law. We're not going into the history of private international law, which is jus inter gentes, right? The conflict of laws. But therein also, much like the entire concept of international law when it was developed, it was being by and large divided into these two parts, right? By and large been divided into these two parts, right? So private international law is dealing of conflict that arises within the domestic sphere of a particular law state, right? So they are in the forms of certain treaties. There are certain and conventions as well. We have Hague Convention with respect to this, Hague Convention on private international law. You will have multiple convention with respect to various aspects covered over there in terms of how nation states are going to deal or arise at the consensus as to how if there appears any conflict of laws which they have prepared or formed within their own domestic setup, what shall be the mechanism of dealing with such conflicts. They are in the form of treaties, convention, model laws, national laws, legal guides, and documents and instruments which, by and large, regulate private international law across national borders. So, what we are studying is public international law, which is law created by state in consensus among themselves. These are laws which are created by states, respective, like in not in consensus with other states, but by their own understanding. Right. So I have made that particular distinction further that private international law serves these two aspects. Yeah. Okay. Just a second. Right. There was this. Am I audible now?
Yes.
Okay. Thank you, Shobha. Yeah, there was this issue. So the two characteristics that private international law deals with is it balances the international consensus with respect to domestic recognition of laws and their implementation. An example with respect to that is your CPC. There's a specific provision in CPC that acknowledges enforcement of foreign, like decrees, judgments for that matter. At the same point of a time, it also balances sovereign actions which with those of a private sector, right? So a certain amount of consensus which arise with any particular, like private sector, say for example multinationals, that also has to be dealt domestically, right? It cannot be enforced under any particular forum of public international law, right? So that particular distinction has to be drawn, which by and large we have understood. I have added few more examples to this. Say for example, I've added this torts, right? If there appears any problem with respect to enforcement or understanding of a tort law among the common law states, then the reference can be made to private international law, right? There is a reference which has to be taken into consideration. There is, I have already informed, Hague Convention on private international law. There is another body as well, which is your International Institute of Unifications of Private Laws, right? That also takes into consideration this particular aspect. UNIDROIT basically being termed as. So, but by and large, we are not dwelling into the realm of private international law. That's something which you will be studying later on. Then afterwards, we were referring to uh, this particular aspect, the international system, what ought to be removed from our understanding of public international law. We agreed to this particular point that international committee is something which must not be referred. There's a system which is available under international law that, like by and large, regulates the conduct of states, and in case if there appears any violation, a particular forum has to be decided. Right? It is not made as such, much like our domestic system, wherein you have a clear-cut understanding as to which particular forum you should be proceeding for any particular issue. You have civil setup of courts, you have criminal setup of courts. This particular aspect, by and large, is not defined under international law. It has to be something which has to be taken into consideration, and determination of a requisite forum is accordingly decided. Right? Then we come to the definition part of international law, right? Because that's also important. The term international law was for the first time coined by Jeremy Bentham in 1789. So prior to this, and that's why that particular distinction was relevant for our purpose to understand, right? Because prior to this particular use of term of international law, there was no such term international law existing uh, in the early part of the 17th, 18th century, right? It was only with the efforts of Jeremy Bentham when he defined as well, right? Because he made an effort to define international law as well, and that became the first, because there was other definitions as well, but that became the first relevant definition for the scholars at that point of a time, right? And it says that international law is a mutual transaction between sovereign states only, right? Because at that point of a time, the only subject that was considered as part of international law was states, right? We will see that there are involvement of other subjects of international law as and when we'll proceed with the definitions of international law. So for the first time, the term international law was coined by Jeremy Bentham. Prior to this, prior to this particular term, there were two terms which were used. One is conflict of law or laws of nations. Right? Laws of nations is something which is public international law. Conflict of laws is something which is private international law. By and large, they were clubbed together within the meaning of international law. Right? So this is what Jeremy Bentham opined, and this definition is important because it only acknowledges states, right? So as and when we'll be proceeding, we'll find out that there are other definitions which were coined, and they accordingly laid down few more aspects to it. Right now we have LFL Oppenheim, right, which is Lassa Francis Lawrence Oppenheim. Now why I have referred this particular name in full, because many a times in your examinations, further examinations that you will be following, you will come across questions which speaks about full form. So it is not that only HLA heart is known, you need to know the full form of what is HLA heart. Right? Just give a cursory read to that, because if you are appearing for competitive exams, it comes. Many a times LFL Oppenheim also comes. We all know about Oppenheim's definition of international law, but what's the full form? Lassa Francis Lawrence Oppenheim. Now he gave two different definitions. The first edition, when he came up with his book, has this particular definition, wherein he says that law of nations or international law, right? Law of nations or international law is a body of customary and treaty rules which are considered legally binding by states in their intercourse with each other, right? This definitions also comes many a times. Who said this particular definition? So just remember few of those important definitions. One, and I have not been covering all the definitions, but very relevant definition that has tremendously made great stand towards understanding of international law, at least in terms of defining it. Much like the definition, because in the early part of our lectures also I said that much like the definition of law, international law is also something that cannot be defined. The latest being the definition of Stark, right? We will refer to that particular definition as well, which even many scholars and in fact, Stark himself acknowledges that is not sufficient enough. So no definition of international law is sufficient enough for defining you what is international law. It has been constantly changing. Laws within the particular states, they've been constantly changing. So is the status of international laws, right? The definition pertaining to international laws, right? So he has two different definitions, right? And in the second volume, when he came up with a different definition, wherein he says that international law is a body of rules which are legally binding on states in their intercourse with each other. Then he says that these rules are primarily those which govern the relations of state, but state are not the only subjects of international law. So look at the amount of changes the definition of international law had taken place from the early, right? Say, for example, the earliest definition that was given by Jeremy Bentham to the definition that was provided by Oppenheim. This is a definition which was roughly around 1890 something on in the early part of the 20th century. The second definition came in the early part of the 20th century, 1903-5, something around at that period of a time, right? So that much of a changes has happened, wherein Jeremy Bentham says that only subject is state, right? Now it says, and within his definition, he says that these are mutual transactions, merely some understanding that has been there between the states, and they have been concluded by states. That what is forming part of international law, to the definition that was provided by Oppenheim, which says that it is a body of customary rules, treaty rules as well. And that's the early phase when treaty gained popularity, because for much of the history of international law, it was largely been influenced by customary international laws, right? Customary practices that state have been following. It has its own implications, because you will find out that much of the laws that has been developed, particularly in the form of like these law of seas, they have been greatly influenced by the customary practices that few of the countries were adopting for a significant period of a time, right? Because law of sea, if you'll read any particular book on law of sea, they will always be quoting that those customary practices, which was largely been there between states like US, Britain, France, all those states who have been exploring in the like these like 17th, 16th, 15th, 18th century, and they ultimately formed and became part of the convention as well later on, right? Largely been influenced by customary practices, but this was a time when even treaties were also gaining importance, right? Much like the present times, the greater part of international law is all influenced by treaties, right? There are lakhs, crores of treaties which have been in existence, right? So customary practices is less of an importance. It is treaty based international law in the 20th first century, right? In 21st century, we can assume that it is greatly treaty based. But before that, it was all influenced by customary laws, right? So we'll be discussing more about this when we'll be studying about customs, treaties, judicial pronouncements more in detail, the sources of international law more in details, right? So these are the changes which he has understood. So he says that it is not just body of rules, but these are primarily which has been governed by state in relationship with each other, and states alone are not the subjects of international law. He acknowledges the fact that there are international organizations, and to some extent he says that individuals may be the subject of rights confirmed and duties imposed upon to them by the international law, right? So there was a change in the attitude which is reflecting in the definition of Oppenheim itself. The first definition that he gave to the other definition that he gave, followed by the changes that were taking place in the realm of international law at that point of a time, right? Because he said that it is only binding upon state and their intercourse with each other is what defining the rules based on customary law and treaties. But now he's saying that there are involvement of international organizations as well, right? And this was an interesting phase under international law for that matter. The entire 19th century, right? is an interesting phase in the international law, which greatly influenced the like the making of international law to a great extent. Because prior to that, it was largely being centered around the practices of states, which are customary in nature and acknowledged by state. They became enforceable. But treaties were also gaining importance. Some of the treaties were in fact recognized and been entered with international organizations as well, right? If you look into the history of humanitarian law, right, that was greatly been influenced during the 19th century itself. So treaties, involvement of international organizations were also being seen. This was a period, if in fact we'll cover that part as well, in like the making of United Nations was also in that particular line, though it was formed later on. But there was a consensus among the state which was made that there has to be an organization which will be assisting the world altogether, the states altogether, in dealing with each other. So there was the making of League of Nations, not United Nations in that sense, but that is what has been reflected in the definition of Oppenheim. Then we have other definitions as well. Justice, like Lord Coleridge, he gave his definition in R versus Keene. That's also a very interesting case, right? It has, like just refer to this particular case, look into the facts of this particular case, right? A case which was between US and Britain, right? And at one point of a time, both of these two states were fierce rivals, particularly in establishing rules pertaining to law of sea, right? And therein he gave this definition pertaining to international law, and he says that this is law of nations in collection of usages which civilized states have agreed to observe in dealing with one another. Now, this reference of civilized state is also found when we'll be referring to the definition of international law. No, the sources of international law, particularly in the Article 38 of ICJ. Now, this is a judgment which is passed by British courts and by a British judge. Obviously, he's been referring to the term civilized. Now, it has its own, problems in the modern times. By and large, academics have been arguing the fact that a reference of these terms like civilized does not, augur well with the current realities, right? What does the world, the global north, want to convey, right, by the term called civilized, right? So that's another argument. But the roots of that particular argument is in the judgments that were delivered by the judges, particularly in defining of international law as well, right? Because we'll look into the history as to how sources of international law came into existence, right? Much of the sources that are reflected in Article 38 of the, your ICJ statute is similar to the similarly placed Article 38 of the PCIJ statute, Permanent Court of International Justice, right? So there is a reason behind it, right? Why they have referred to the term civilized over there. So this is another definition. Then you have William Edward Hall's definition, right, which says that international law consists of certain rules of conduct with modern civilized states. Now he went a step ahead and he says that modern civilized state regard as being binding on them in their relations with each other, right? So this is another definition with respect to international law. Then Brearley, right? Many a times you might be referring to that particular book as well, a very reputed book of international law. He also made an effort with respect to defining international law. Now he says that international law can be defined as body of rules and principle of action which are binding upon civilized states in their relations with one another. Right? Again, a definition which is in consonance or in agreement with the definition that was provided by Hall as well as Coleridge, right? Lord Coleridge. Now, there is another definition. George Schwarzenberger, you will refer to this particular scholar as well many a times when you will be studying international law. He also made an effort for defining, and he says that it is body of legal rules which apply between sovereign states, and as such other entities as has been granted international personality, right? So now he moved ahead and acknowledges the fact that international law has been advancing towards not just granting international personality per se to the states alone, but also to other entities, right? Other entities like international organizations, individuals, right? So he acknowledged those particular aspects and he says that accordingly, whatever sets of rules have been agreed among them, whosoever like comes within the meaning of international personality and their dealings can form part of international law. The, like the latest definition will not be saying it as a latest definition, but this is a definition of 20th century, right? And which is given by Stark, right? Joseph Gabriel Stark. Now he says international law. Now this is the within the introduction of the book, right? That this which is Stark's international law. Many of the scholars refer to that particular book. It's not that lengthy comparatively to the one which has been provided by Brearley or by Oppenheim. But in the introduction itself, he starts with this definition. The first line of his book is what has been reflected in your screen, right? He says that international law may be defined as body of law, which is composed for its greater part of principles and rules of conduct which state feel themselves bound to observe and therefore do commonly observe in their relation with each other, and which includes also the rules of law regulating to functioning of international institutions or organizations, their relations with each other and their relations with state and individuals, certain rules of law relating to individuals and non-state entities, so far as the rights and duties of such individuals and non-state entities are the concern of international community. Now, this is being considered as the most like updated definition of what can be constituted as international law in present times, but even there it has not acknowledged the present time. So by and large, the understanding is that much like the definition of law, which cannot be defined and has its own protein faces, similar is the case of international law. But the entire history of defining of international law is quite relevant for our purposes, right? Starting from the definition of Bentham to the definition that has been provided by Joseph Gabriel Stark, right? And he acknowledges many aspects. He says that there are new emergence of bodies like WHO, which has been greatly influencing international law. And this is what something he has referred in his introductory part itself, right, of the definition. So these are by and large the definitions that we will be covering and gives us a reflection as to how international law has proceeded over the course of time, right? It has advanced to a state wherein only states were considered as the primary and the only subject of international law to a position wherein they have been acknowledging the fact that others other than state can also form part of international provided these conditions have been fulfilled, right? Which is laid down under Rule 1 and 2 of the definition that has been provided by Stark. Right. Now we'll move to the history part, and then the definition will be more understandable when we'll move into the subjects of international law, when we'll understand the sources of international law, right? Or other aspects like the dealings of municipal law with international law, right? Involvement of international law commission, how does it came into existence, which provision of UN Charter itself speaks about formation of international law commission, how important that particular body of is important for world altogether. They have been assigned with certain tasks, right? And they have succeeded to a great extent in enforcing certain customary practices within the realm of international law. Say, for example, greatly to this to this particular body of law of seas that has been formulated, the credit largely goes to the efforts of International Law Commission. They've been working on various other projects as well. We'll be dealing more in detail about that in the coming classes. Right. So all of that is a reflection of how international law has advanced over the course of time. Right. For the time when it was only states to a time when other organizations, right, having international characteristics attached to them, or individuals for that matter, have also becoming part of international law. And over here, when we are talking about international law, it's by and large the meaning public international law that we've been referring to. Right. Now, what is the history behind making of international law? Because that's also crucial and important. Most of the occasion, it has been generally understood that international law developed only in the later half of the 18th century and the entire 19th and 20th century, right? But there is a history behind formation of international law. Its existence has been understood as something which was always been there. The moment state has been formed, right? Uh, there was existence of international law, right? There are many examples with respect to this. Any book that you will be referring to will definitely quote that particular part, that since the formation of a state, international law is in existence. The importance of international law is only being understood in the later half of the human history, right? By and large, by the 15th, 16th century, right? By Hugo Grotius and all others, right? But the reference with terms of international law was always been there in existence, and this was in existence in Roman Empire itself. The Roman Republic, they also have reference of international law wherein they distinguish these aspects, like the aspects pertaining to international law, into two parts. They said that there's jus gentium, which is your law of nations, and there was this jus inter gentes, which is agreements that has been entered between these nations, which by and large is a distinction that we can form with respect to. Just a second. Is there anyone? Which is by and large what we understood as private international law, within the realm of private international law, but will not be like the manner in which private international law has developed cannot be in the sense understood from the perspective of Roman per se, right? Now, public international law is said to cover relationship between states, right, in the forms of treaties, law of sea, international criminal law, war, humanitarian law, international human rights, refugee law. In the recent time, it is also like entering into the realm of air and space laws, right? Because that's normally not part of our syllabus, but that's also an area wherein public international law is has having its effects, and right, and it is something which is still in making, right? Though many a times we believe that it is something which is again of recent origin, and in international law, recent origin is not something of last 5 years or 10 years, right? Recent origin we generally assign to something that has happened over some 100 years, right? Say for example, with respect to space laws, right? By and large, the writings on space laws initiated in the early part of 20th century itself. In 1910, somewhat around at that period of a time, a thought was there in the mind of few academicians who are believing that now, other than seas and land territories, there is an area above land and sea, which is air and space outside, right? And that ultimately saw greater momentum with the kind of competition that took place between US and like Russia at that point of a time, right? And there afterwards, the entire jurisprudence pertaining to space law emerged, right? So it's a recent origin, recent to a sense that any book that you will be referring to international law will not have dedicated chapters on air and space law as such as of now, but it has been changing over the in the recent time. It's becoming a subject altogether of its own. So again, that's an area which will not be entering into for the sake of our syllabus. We'll restrict ourselves to these particular aspect as to what has been referred in the syllabus alone. Law of sea is being part of it, right? It has its own relevance and history behind it. So while private international law is commonly known, this is something which we have already covered, right? It deals with which court or which or within the jurisdiction of which state a particular conflict of law has to be settled down. Those are mainly with respect to torts. Those are mainly with respect to intellectual property as well. You will also find reflection of private international law dealing with IPR issues, right? Because many laws have been formulated by states and they regulate, right? Cases against multinationals, those are also part of it, right? Then you have issues pertaining to family laws, right? I have already given you an example earlier: divorce, marriage, right? Adoption, for that matter, all those forms part of it. Contractual relations also having international characteristics; those are also dealt with in the realm of private international laws, right? So it has its own unique field domain altogether, right? Now, the origin of international law is traced back to antiquity, and this is what I was reflecting. There are many various like evidences, historical evidences that suggest to this particular aspect, right? Uh, in various parts of the world altogether, wherein you will come across like certain evidences that suggest that there was reflection of like law of nations at that point of a time in those societies, or like regimes for that matter. Now, ancient Greece, they developed this notion for the first time. They developed this particular notion of governance of international relations. Like by and large, it happens because of like in the early part, it was because of the trade, right? So as and when the trade moved outside the territory of a particular state and certain like transactions takes place between various states, there was a need to regulate that particular aspect. Much like the meaning of law that you have understood, anything that demands regulation will bring out a case of law. Similarly, anything that is done between the sovereigns, because there was a question which was raised at that point of a time as to how this particular scenario needs to be taken care of. Because now trade is not just within the state, now it is moving outside the states as well. There are also exchange of like diplomatic relations as well, because in order to enforce those particular trade agreements, you need to put your diplomats as well, right? And how you are going to govern or regulate their conduct, all those things were part of international law. Greece became the first state that basically developed the notions pertaining to governance of international relations, and thereafterward this was also been followed by the Roman Empire, right? And they distinguish this particular aspect in two forms: just gentium, which is law of nations, right? And in over there, they used to govern the status of foreigners who are living in parts of Rome, right? And their relationships, the state's relationship with those particular foreigners, or with the foreigners and their relationship with Roman citizens, right? So they largely developed this particular notion of jus gentium, right? That particular document altogether takes care of this particular aspect. They followed the Greek concept of natural law in understanding and developing this particular domain. And in that process, they said that this is something which is universal of having universal characteristics. Right. I need to, who's the CR for this class? I will just put, because yeah, Shifali. Okay, Shifali, I will just make you the presenter. Okay. So you can just let in those students. There's a lot of students who are having this network issues, right? So they've been rejoining. Anyways, so Greeks accepted, they followed the concept which was developed by Greeks on the lines of natural law school, and they believe that this concept of jus gentium, which is law of nation, is universal in nature. That this has to be applicable across states, because whosoever is dealing with foreigners through trade and various other aspects, they have to take care of this particular aspect. Right. Now, in contrast to modern international law, the Roman law of nations applies to relationship with and between foreign nationals rather than political units. Right, because they said that the sovereign is not subject to any regulations. Right. So this was by and large a thought at that point of a time. Now, Romans had set up like a team of roughly around 20 priests, right? And priests they used to refer by the term fetiales, right? who manages the functions regarding relations with foreign nations, right? And this is an interesting aspect. If you have studied natural law more in detail, you will find out that there are four classifications of natural law, right? The natural law which was developed during the Greek period, largely been influenced by Plato, Aristotle, right, and Socrates at that point of a time. That was the conventional form of natural law, and they were reflecting on ideas pertaining to morality at that point of a time, and believing that something of the highest nature has to be attributed behind making of any particular law, right? But you have also found out that as soon as that particular period gets over, there was a second phase of natural law, which was largely being developed by religious laws. Right. And this is found in Roman Empire, the Roman Republic. They were greatly been influenced by, like the philosophers who emerged from, like these religious institutions, right? Saint Augustine, all those things. So therein, for political aspect, that your head of a state will be like subject to these particular norms that were of universal nature, whose gentium will be, like he will also be subject to them. This was not something which was conceived at that point of a time. What they rather followed is that there was a team of 20 priests, and they will deal with this particular aspect of, like functions related to international law. Right. Now, over here, these fetillers or priests did not apply pure secular law, right? They applied divine and holy law, and that formed the, the genesis of Us Sacrorum, right? This is what is known as also Us Fetilla, right? So this is how international law developed at that point of a time. The idea behind reference of this particular point is that it has roots still in antiquity, right? The international law is not something which is largely been developed during the 15th, 16th century onwards. It is something which has in existence since the formation of a state, since the interaction of people of a state with other states, right? And this is how the entire history of international law originates. Right now, after the collapse of Roman Empire, right, roughly around in the 5th century, Europe, the entire domain of Europe got fragmented into various regions, which were oftenly being engaged in wars, right? And this continued for a significant period of a time, right? There was no clear-cut understanding as such, right? Uh, and then largely the interactions of one particular state was dependent on this, like people who have their control with the, or who are part of churches at that point of a time. Now it's also interesting over here that this, that like, because many a times you do refer to the term church, right? And it doesn't mean a religious institution altogether, because it has its political power as well, right? If you are in good terms with churches, the possibilities of you not having war with other states were higher enough, right? So they controlled by and large the functioning of various states. So they became powerful. And this is also reflected if you have studied legal history more in detail, how, like in Britain itself, in UK itself, there was a great influence of church at one point of a time. There was tussle between king, church, and the parliament, right? And the safer route to this particular trouble emerged in the form of introduction of your judiciary, right? If you have studied the history behind the establishment of House of Lords, right? It has its own unique history, right? So the organ of a state, a very powerful organ of a state, in fact, like now it's becoming more and more important in the modern times, right? That's why you have realist school emerging, right, from judiciary itself, right? Who are the proponents of real school? Those are all judges, Justice Holmes, Cardozo, right? You generally, Justice Gray, you will study about those particular scholars, and they propose that law is something which is developed in the courts through the agents of courts, lawyers and others, right? This is what by and large is the domain of realist law school. So, but for a greater period of a time thereafterwards, once the control of managing the relations with other states went into the power of these religious institutions, there were continuous wars. There were no fixed territories. If you'll refer to the initial understanding of what Romans, like formulated during the establishment of this concept of law of nations, they acknowledges each other's territory. Not just that, they acknowledges even the boundaries, jurisdiction, and the people, which was largely being seen, like forgotten post 5th century, and that continued for a significant period of a time. Whosoever has might and power, they control over the territory of others, until and unless Treaty of Westphalia was formulated. That was considered as the landmark, like effort in developing something called international law, truest sense of international law, or what can be construed as a further betterment to the concept which was originally being initiated by Greek philosophers, supported by Romans, Jus Gentium, right? So they said that in order to acknowledge international law, first and foremost is the acknowledgement of the boundaries of each territories, right? It didn't, like it didn't help greatly to the world at that point of a time, because even after formation of Treaty of Westphalia, the world continued to remain in war, especially the parts of Europe. And from there itself, the reference of the term civilized states comes into picture, because they said that once that particular Treaty of Westphalia was established, and thereafterwards some efforts were made towards acknowledging the territory and boundaries of other states, and thereafterwards developing certain, like interactions with others, these states have attained the status of civilized state, that they will argue, they will have doubts, or they will have any particular issues with each other in a manner which is properly formed through certain understanding, consensus. Right? What is by and large this particular Treaty of Westphalia? It was basically a consensus that has been arrived among the rulers of various regions of Europe, that they will acknowledge the territory of others. Right? And in that process, the emergence of nation states came into picture. Right? But that's the landmark, and thereafterwards, like that's why when you are studying international law, or when you are studying law altogether, you need to go to the roots, the historical roots of that particular domain, area, right, or subject. This is how international law developed altogether over the course of a time, and greatly to that particular. And that's why in many books you will have reflection of Treaty of Westphalia as a most advanced form of understanding that state could have arrived at, and that ultimately resulted in understanding or bringing of this particular concept of civilized states. And this is what is reflected in the definitions, various definition that has been propounded and proposed by Lord Coleridge in R versus Keene, Hall for that matter, right? Because he says civilized states, Hall says modern civilized states, right? So this is important for our understanding, right? As to how and why the scholars of third world country and developed country has doubts with respect to use of the term civilized, because they believe that, the roots only just merely their understanding of law does not claim or put them into that particular position of what is civilized states, right? Or in the indirect manner, what they've been enforcing upon us, that these are the methods which leads you to this particular meaning of what can be termed as civilized, right? So this is how the issue with civilized state has, right? Many a times when you'll be start looking into various like lectures of international scholars, therein also you will have some amount of comment to this particular term of civilized state, because it is there in your article 38 of ICJ, right? So this is how. Now there is another side of history of international law which is by and large missing in your international books. Oppenheim, right? But this is reflected in some parts of, not in detail, but some parts of Malcolm and Shaw's book, right? They do not believe that there was parallelly another system that also acknowledges international law, other than what is their own Western, or the understanding that was reached by global north states. Now, international law has also tremendous amounts of attributes from Islamic jurisprudence, right? Now, even if you look into the Islamic jurisprudence, there are three categories, right? These are part of their text. That's why you cannot disregard their involvement in making of international law. In fact, the the newer and modern understanding of international law is also suggesting that there were efforts on part of Chinese state as well towards the development of international law, or to what extent Indian jurisprudence as well, right? Indian jurisprudence also attributed to a great extent for the formation of international law, right? Especially in terms of understanding globalization, we always have reflection of that particular quote, Vasudhaiva Kutumbakam, right? The world is all together one global village. So it is not that the Western philosophies and their history alone created international law or acknowledges international law, right? There were efforts made from other parts of the world as well, right? That's what is the debate, the global north versus global south debate. Because north believes, or the Western states believe, that they are the one who have made tremendous efforts for bringing of this concept of international law, which is rightly been rejected by the scholars of third world and developing states, wherein they argue that our own texts also have reference of international law. Right? We also have our ancient text wherein we have made reference of diplomats, right? Or say, for example, with respect to globalization and all others. So Islamic law, at least in their text, they have also made, and their jurisprudence has widely been accepted in your humanitarian laws, law of wars, right? Particularly over there. Now they have categorized three categories. One is Dar al-Islam, which is territory of Islam, right? Then they have second territory, which is Islamic, wherein completely Islamic law prevails. Then they have Dar al-Sul, which is territory of a treaty, wherein non-Islamic realms have been concluded, right? So you will have a government which is Muslim government or Islamic government at that particular period, and accordingly they will be formulating their laws, right? But this is not something which is within their own territory, purely not their own territory. Then the third category is Dar al Harb, wherein which is the territory of war, right? And therein non-Islamic land, these are parts of non-Islamic land and rulers, and accordingly when they accept Islam, their laws will be implemented on those areas. So this Dar al Harb is a quite influential document with respect to understanding law of wars, right? Most of the concept that you will find in law of wars will have their roots to Islamic jurisprudence, right? So largely in the form of how military should conduct, right? How treatments of prisoners should be made, or like all those aspects which forms part of modern international humanitarian law is found reflected in the text of Islamic jurisprudence as well, right? And this is something which is relevant for our purpose to understand, because by and large what we have been taught by these international books or by Western philosophers is that it's because of their own efforts the international law developed, which is not the case. There are others, like systems which also hugely contributed towards the making of what we mean in present time the modern international law, right? In Islamic law, you will have an institutionalized humanitarian setup, right, with respect to how military should conduct, how attempts to limit wars has been made, guidelines with respect to hostilities, how they will be treating over there, then distinguishing between civilians and combatants. This is again a very important area. There are clarifications, but those clarifications are still not clear enough, right, between civilians and combatants, right? Then we have unnecessary destructions. This is something which was held like illegal under the text of Islamic jurisprudence, right? How to take care of sick and wounded, soldiers, right? that is also something which is reflected over there in their documents, right? They have also made efforts towards how prisoners of war should be treated, what manner in which they will be provided with shelter, food, clothing, how their culture will be respected as well, right? And like uh, preventing any particular act of execution, rape, or revenge. This is all something which is part of Islamic jurisprudence. Not that has been understood in the literal sense in present times, but they have text that have taken care of all those aspects. If you reflect it from the kind of treaties and conventions that are part of humanitarian law, you will find similarities. By and large, it is also a customary practice altogether, right? Which has been acknowledged over there. So Islamic jurisprudence also contributed immensely towards the making of the international law, right? Now, during the European Middle Ages, international law was primarily with respect to this aspect itself, legitimacy of war, seeking what constitute a just war, right? This is again having its roots to natural law itself, right? School of natural law, just war. Anything that can be that can fall within the meaning of just war is permissible. Anything which is prohibited within the meaning of just war, and world have different understanding with respect to this, right? And Thomas Aquinas created this particular discipline of law of nations, and he largely uses natural law school over there. Now, Thomas Aquinas is again a person who belongs to the church, right? He was in fact a priest, and accordingly gave his own opinion against the like holy law. He had a different take towards the law that has been like proposed on behalf of churches. Right? He's been also attributed as a naturalist to that extent, because he says that there are distinctions within laws as well. One which is divine law, holy law, law which is being made by like by humans, and he said that the law which is made by humans is something which has to be prohibited, right? That's a kind of distinction he made. Now, the greatest of efforts towards the making of modern international law is your 15th century onwards, right? Wherein large areas of Europe were evolving into number of independent civilized states. Right? This is why I was reflecting to this particular argument of civilized states. Right. So I will stop at this point of a time. It's 10:57 now. So we can just go to the attendance part first. And then in more in detail, if any doubt will be there, we can refer it in the next class. I will just call the name Arnav, Anamika.
Anamika present, sir.
Okay, Karanveer.